Back in 2021, the federal government told the many companies whose stock is traded on the Nasdaq stock exchange that the membership of their boards needed to conform with certain gender, race, and sexual orientation quotas, or they'd be kicked off of Nasdaq unless they could explain why their boards were not diverse enough. The New Civil Liberties Alliance took one look at this proposal and knew that it was unlawful, and so did the National Center for Public Policy Research, NCPPR, our client. Because this rule was approved by the Securities and Exchange Commission, we were able to file a lawsuit directly in the U.S. Court of Appeals, and the entire Fifth Circuit ruled 9-8 that this rule was unlawful. The full case name is Alliance for Fair Board Recruitment and National Center for Public Policy Research versus the Securities and Exchange Commission, but we often just abbreviate that AFBR v. SEC. The rule appeared to be part of the corporate drive for DEI, diversity, equity, and inclusion, taken to the board level. Here to discuss the historic ruling are two NCLA litigators who led the charge against it. Senior Litigation Counsel Peggy, who argued the case in the Fifth Circuit en banc, and Sheng, Litigation Counsel, who helped with the briefing of this case. Peggy, Sheng, welcome to the program.
Thanks, Mark.
Thank you.
Let's talk about the far-reaching implications of the board diversity rule being set aside. Sheng, what was in the board diversity rule? Let's start there.
Yeah, so under the Securities and Exchange Act, Nasdaq is what's called a self-regulatory organization, and when they change their rules, they have
a self-regulatory organization?
That's right. And
okay.
so it's a kind of
an SRO,
that's what they call it, yeah. And so what happens is when they change their rules, they have to go through a rulemaking process much like the federal agencies do. And SEC gets to approve, vote up or vote down their rules. And without SEC approval, Nasdaq rule changes don't have any legal effect.
Sure.
So what happened was in 2020...
So they can't do this on their own. They have to have SEC's approval.
Exactly. So there's some governmental supervision of what they're doing.
Yeah.
And so in 2020, Nasdaq proposed a set of diversity requirements, which SEC approved in August 2021. And those requirements can be broken up into kind of three components. The first is a disclosure component. Every Nasdaq-listed company must disclose what's called a diversity matrix. Then they have to disclose the number of women, the number of kind of racial minorities, and the number of sexual minorities, LGBTQ plus, who sit on their board of directors. The second component is a sort of a quota or explain requirement. And there, the Nasdaq-listed companies and their boardrooms have to meet certain diversity requirements, and Nasdaq called these aspirational diversity objectives. And you have to have one woman on your board, one self-identified female, and you then as a member of your board, and you have to have a second diverse director who must be either a racial minority or a sexual minority. So for whatever reason, they decided that like a transgender or gay person, it's a substitute for a Black or Hispanic person, but they satisfy the same slot, diversity slot, but women get their own diversity slot. And those are the two sort of diversity components. So there's the disclosure and the quota. And the third component of the proposed rule is a recruitment rule that Nasdaq hires an outside company that for any company that cannot satisfy the quota, that the outside company will give them a list of kind of diverse, pre-qualified candidates for them to recruit onto their board of directors.
Peggy, what was one of the legal arguments that NCLA made in this case that led the Fifth Circuit Court of Appeals to strike down the board diversity rule?
One of the arguments we made, and fortunately it was the winning argument, is that the 34 Act, the Securities and Exchange Act, as amended, does not allow SEC to regulate in this field.
Doesn't allow it to regulate in this field, meaning what? They can't regulate boards of directors?
Well, they can in certain limited ways, and the decision gets into that. But they're there to regulate markets, securities training, to have fair and open markets, competition and training. They are not there to decide who sits on boards of directors of American corporations.
Got it.
And an important part here is to understand what Peggy just mentioned, the 1975 amendments to the Securities and Exchange Act, which the decision goes into in quite a lot of detail, and I recommend that reading for the readers if you're interested. But what that did is, according to the court, it clipped SROs. So SROs like Nasdaq are not allowed to make rules that are not that regulate matters not related to the act. And SEC is put in a position to stop them if that's what NASDAQ and other SROs are doing.
So let me see if I follow you. So Congress has given certain power to the SEC to regulate markets. These self-regulatory organizations themselves regulate the companies, but if they want a rule that's going to be binding on the companies, then the SEC has to sign off on that rule, and the rule has to be within that same sort of sphere that the SEC is allowed to regulate, where Congress has given it authority.
Exactly, and the racial and gender makeup of boardrooms are outside of bounds.
What does this ruling mean for NASDAQ-listed companies, Peggy?
Well, it means that they do not need to make these disclosures and meet these two-seat requirement that it's under the act, and they can just continue to hire who they think is best qualified to sit on the boards of directors.
Yeah.
And it's important, I think, to add that as the opinion mentions, they can still advertise the diversity of their board. Nothing stops them from doing that. They're just not mandated to meet these quotas anymore.
Right. So nothing prohibits them from being as diverse as they want to be, but it's just not a requirement.
Precisely. And so different companies can have different strategies, and we have a free market for that.
Were there any other key arguments that NCLA made against the SEC's approval of the NASDAQ rules?
Yeah, we made an argument that's related to the statutory argument. It's called the major questions doctrine, which is getting a lot of play in the Supreme Court and other courts of appeal recently. And this is basically saying, finding that Congress doesn't hide elephants, like massive regulatory power, in mouse holes, with small, vague language. And what SEC did is they took vague language from the 1934 Act, such as promote open and free markets, and they took that and said, well, we think this means regulating the racial and gender makeup of boards. And when you have an issue like this, which is this is an issue that something like $20 trillion of stocks are listed on NASDAQ. Racial and gender diversity and quotas are a very politically significant issue. We just had Supreme Court decisions about it. Plus, the corporate governance of companies, they're really a state law issue, because these companies are all incorporated under state law, most of them Delaware, but other places as well. And when agencies seize power to go and basically invade a traditional area of state regulation, you would expect Congress to give them clear statutory authority to do that. And here, there just isn't any clear language.
Peggy, did you think you argued this case in front of the en banc court? Is this how you thought it would turn out, or were you surprised by the decision at all?
I wasn't. It was a good argument. I thought the judges were very engaged. They asked good questions, hard questions, and I had my fingers crossed carefully.
Anything stand out from the argument?
Well, they had some good colloquy about the idea that this is just a disclosure rule. And the problem with that, and the problem with regulating in this matter, whether it be this rule or any rule outside of an agency authority, is these are pretexts. And they say it's just a disclosure rule. And so the court started to say, well, what about asking candidates about their religion? Or if they're Taylor Swift fans, or, you can't just say this is just a disclosure rule.
It really was the year of Taylor Swift when she's coming up at Fifth Circuit on oral argument.
But there's no limiting principle to that idea of this is just a disclosure rule. And I think that got exposed very effectively at oral argument. And that's one of the key reasons why I had hoped for this decision to turn out the way it did.
Sheng, how does this decision affect other SEC authority moving forward? Could it limit similar rules in other areas?
Oh, definitely. So to understand, first of all, even though the decision had to do with the NASDAQ rule, the way it works is NASDAQ was essentially making a rule sort of on behalf of SEC, and that's why SEC has to approve it. So the ruling about the NASDAQ's disclosure authority to make disclosure rules has really derivative effects on SEC's authority as well. And here, the majority opinion said the Exchange Act is not just doesn't authorize SEC to have writ large disclosure authority. Any disclosure rules that either NASDAQ or SEC makes are going to have to be related to the purposes of the act, and that's to ensure or to fight fraud, ensure open markets, protect investors, that sort of thing. And here, the court said, well, okay, having drawn those lines, we find the racial and gender makeup of a boardroom to fall outside of those lines. But the SEC has colored outside of the lines in the past and may do so in the future. And this decision certainly reins it in. And in one important case that's ongoing and where NCLA is representing also NCPPR again against the SEC is the climate disclosure rules that SEC promulgated last March, which require all companies, not just Nasdaq company, but all companies to disclose all kinds of kind of environmental related information regarding their greenhouse gas or downstream effects of their business, including anticipating future government regulation. And under the SEC theory in this case, which is say we can make anyone disclose anything we want, maybe they can do that. But the Fifth Circuit decision here says no, you cannot. You have to tie your disclosure requirements to corporate governance, to fraud, anti-fraud, investor protection measures. You can't just invent things and then regulate things that have nothing to do with financial markets.
Peggy, let's talk about the disclosure aspect of this rule. One of the things that jumped out at me is the fact that we don't know any of the companies that belong to the Alliance for Fair Board Recruitment because that information was sealed at the beginning of this proceeding. Why have companies been so reluctant to be public about this rule, and what does that reluctance tell us about the rule itself?
The record was sealed as to the identity of the corporations that were part of AFBR right from the beginning, and no one objected to it, and the court immediately entered that order. That is very telling, because normally people who are in litigation need to identify who they are. But these corporations submitted materials showing a genuine fear of adverse effects, such as boycotting, cancellation, and real harm to their business. That is telling. And the court acknowledged as much in its opinion, which is refreshing. Here's what the court said, quote, "Corporations that do not meet these objectives must explain why they failed. That is not a disclosure requirement. That is a public shaming penalty for a corporation's failure to abide by the government's diversity requirements." That
naming and shaming.
Naming and shaming, and that is exactly what is going on here. And it is refreshing to see a court say it out loud.
Yeah, it is interesting to see the court willing to recognize that that's what was going on here. What was the reaction from the public to this decision, Peggy? Were there any particular reactions that struck you? What's the man on the street's reaction to this sort of thing?
Well, I think the stripping of individuality to people working in business on the basis of racial, gender, and sexual orientation deeply offends our widely shared beliefs in this country that people should not be categorized or promoted in that fashion. And in fact, there was an interesting tweak from Vivek. He was noting that this is not the first time the SEC has met with defeat in the courts for this kind of regulating outside of its regulatory guardrails. And what he said is when an agency like the SEC is so repeatedly and thoroughly embarrassed in federal court for flouting the law, it loses its legitimacy as a law enforcement body. Yeah. It's a powerful statement, and I think an accurate one.
And it's been repeatedly and thoroughly embarrassed by you in your multiple litigation wins.
NCLA.
Sheng, what did you think of the Vivek tweet?
Oh, I liked it. And I would also note that it was a retweet of Corey Leo, who is a friend of NCLA. He was local counsel in the case where we sued the Department of Education for some of its discriminatory regulations in the past. And he actually also filed an amicus brief in this case.
Yeah, it's fantastic to see Corey tweet that and Vivek retweet it. And there has been quite a bit of positive reaction to the court's decision. I don't know if maybe that reflects that the tide has turned on some of the DEI mentality in corporate America.
I think that's true. I think you read a lot of articles that people are increasingly skeptical of this DEI, whether it is in woke corporations in America or throughout other large sectors of our nation.
And I would add that even SEC wasn't even sold on it when they approved the rule, because when Nasdaq sent the rule for SEC approval, Nasdaq said, hey, this sort of diversity is going to improve corporate governance and corporate performance, and that's why disclosure is important. And SEC reviewed the evidence and said, this is at best inconclusive, and decided to approve the rule for other reasons as a disclosure requirement, as opposed to sort of furthering these diversity objectives. Now the court shut that down, but I think it's even important to note that even SEC didn't buy this supposed relationship between diversity on these very superficial demographic characteristics and corporate performance.
So Sheng, what does that mean if the agency takes its eye off the ball and is focused on something like the board diversity rules instead of what Congress had told it to focus on?
Well, it means the agency isn't doing the job that Congress gave it. It's trying to do some other job. And when it tries to do that other job, it's going to drop the ball on its actual responsibilities. And we see this all the time in the last couple of years. Not only in this case, but for example, you had a workplace safety agency trying to impose a nationwide health vaccine mandate. You had a health agency trying to regulate housing markets. And you have the Department of Education, because they were so focused on canceling loans illegally, they dropped the ball on FAFSA, and you have thousands of students not getting financial aid. So in the SEC context, when they try to regulate here, the demographics of a boardroom or, climate with the EPA's job, what they're not doing is chasing down insider tradings. They're not chasing down financial fraudsters. And ultimately, the American people in the security market suffer.
What about that, Peggy? These agencies sort of doing things that aren't part of their remit?
It's very openly acknowledged by this administration that this is a whole of government initiative. They'll pick a cause, whether it be climate or DEI or
two big examples,
or misinformation, and then they will try to get every agency that can plausibly do so regulate in that space. This kind of regulation, whole of government, is fundamentally dishonest in its origins, and it's dishonest in its execution. The court's decision was a masterclass in statutory interpretation that found that the words in the Exchange Act as amended could not bear the weight that they were being asked to bear.
So the court decided that the SEC can't do this kind of regulation on its own. But Peggy, could Congress attempt to create a similar rule with a different justification?
Well, it could attempt to. I don't think it would. And that's also a very interesting point here. I don't think the American people are in favor of telling corporations who they should have on their boards. But even if they did regulate in this sphere, there are important constitutional problems with such regulation.
And
even
both
for
of the
Congress.
parties made constitutional arguments in this case, but the court didn't reach them.
It didn't need to, because the statute simply did not permit this kind of regulation. But I think even Congress could not regulate in this manner.
And Sheng, what about any other rules that are pending right now that SEC has approved? Will it affect any of those?
Oh, for sure. I mean, this decision, trimmed back a lot of what SEC claims to be its power to force companies to disclose all kinds of information, and NCLA's litigation against SEC's climate disclosure rule is in the crosshairs. You might even think that the majority here was even thinking of that climate rule. In fact, I think Judge Jones during oral arguments mentioned the climate rule as something that encapsulates SEC overreach. And so if SEC's disclosure requirements, that they can only have disclosure requirements about actual financial information that's related to investor protection and fraud, that means, for one, they can't do this. They can't force disclosure of demographic information, and they call it a disclosure. They can't force you to explain why you don't meet a quota. But at the same time, they also can't force you to disclose these climate-related information that have nothing to do with a company's profitability, corporate governance, or anything that investor might actually care about for investment reasons, not social justice or DEI reasons.
Yeah. Peggy, the SEC and the litigation had made the case that, well, investors wanted this information, and therefore it's perfectly fine for us to require that it be disclosed. What did the court say about that particular line of thinking?
Well, I think that the investor demand justification for the rule just proves our point, which NCLA feels very strongly that laws must be made in Congress. We don't make law in this country when BlackRock or CalPERS or Goldman Sachs decide that they want to promote DEI across an entire exchange. That was not a democratic vote. It was not something that the people of America decided it should do. And the investor demand justification is just as vacuous as this is just a disclosure rule. I mean, how many investors? Who? Why should they have the power to determine these? Those are all good questions. And the court sought its guidance in the statute, which it read carefully and closely, and the history of these laws, and determined that investor demand was not sufficient justification for these rules.
And we made this point in our brief that it wasn't so long ago in our nation's history that maybe investor demand, we shouldn't have been so proud of investor demand. Investors would have wanted fewer women, fewer gays, fewer minorities in boardrooms. And under the SEC's reasoning, they could have, in the 60s or 70s, published a rule that this exact rule to give investors information so that those investors can discriminate based on these demographic characteristics.
And as we argued in our papers, there is investor demand to find out whether people do business in Israel or make investments in Israel. And those are not the kinds of disclosures, no matter what the demand for it is, that the government should be participating in making.
So in other words, the SEC shouldn't be facilitating discrimination.
Precisely.
Yeah, and in any event, the investor demand rationale the SEC gave is really boundless, right? Like, this is how oral argument developed into Taylor Swift land. It's because if you buy their argument, it does get to this absurd point where really anything, the SEC can force disclosure of anything based on some pretext of some investors wanting it, and even Nasdaq in the final oral argument walked away from that at the very end. They said, well, wait a second. We don't mean anything. What we mean is, it has to be investor demand, and it has to be backed up by evidence that it improves performance and all that. But again, that also failed because
it wasn't.
It wasn't backed up by evidence, but it also contradicted SEC's point that the Security Act, Security Exchange Act, gives them power to disclose, force disclosure of anything.
Peggy, did NCLA point out other problems with the rule in the briefing?
It's hard to envision how these rules could even be implemented. What do you do? Do you ask someone, do you identify as a woman? Who do you like to sleep with? What is your...
Not a usual employment conversation question. Yeah.
Right. And what is your ethnic background? And in many states, all of those questions, or some or all of them, are illegal. And so there was, as I say, there's a dishonesty at the core of this kind of regulation, because I think they know they really can't do this, and they're trying to follow a fad to regulate in the DEI field. But when you have to ask illegal questions to even implement the rule, I think that shows the hollow heart at the center of this kind of regulation.
Sheng, what did the dissent have to say? I mean, this was a 9-8 decision, pretty closely fought battle. What were some of the areas of disagreement between the majority and the dissent?
They really differed in how they interpret the 1975 amendment to the Exchange Act, whereas the majority said the amendments brought the SROs under SEC control and required SEC to be vigilant in approving SRO rules, reviewing them, and making sure they don't that they further objectives of the act. The dissent took a much more limited view of SEC's purview and said, well, SEC really just stands there and sort of
kind of a free to be you and me 1970s sort of
perhaps,
approach.
And maybe that's what's going on in the 70s. But the idea was that SEC has a very limited role, and as long as the SRO's rules have some plausibility, some nebulous connection, then SEC should be rubber stamping it. And this was consistent with sort of maybe slightly different from the panel decision that was vacated by the en banc whereas the panel decision really did go in and try to find, find a connection between the purposes of the act and the
contents
diversity,
of the rule.
Right, exactly. Although the panel decision was pre-Relentless and Loper Bright, and I think it gave a little bit of, it didn't call it deference, but it gave a little bit of deference by saying, by using a standard called the substantial evidence standard, which it's one of these terms that in law that means the opposite of what you think it means. Substantial evidence means any amount of evidence, it's enough. Even the barest amount of evidence is enough, which is a pretty deferential standard that the majority opinion here did not use.
You should call it the scintilla of evidence standard.
Exactly, yeah. Like rational basis. It doesn't actually mean that.
Right.
Well, and I think the dissent was somewhat glib and facile in saying, oh, this is just a disclosure requirement, and that we want private ordering in this sphere. Well, it's not private ordering when it is a rule. And one of the things it did not mention, it didn't get a lot of play in the decision, but is very important, is these companies are subject to delisting if they do not comply with the government's requirements in these rules. That's a very severe penalty. And it's not just free to be you and me. You're talking about a major penalty that can be imposed upon these companies. And I think the dissent just did not squarely face up to that issue.
And companies have to list on an exchange. You can't just decide to trade publicly on your own.
And that's where it's glib, is to suggest that
there's other exchanges out there, right? But there's only a few, and under the dissent's reasoning, they could all do this, in which case a company is out of luck. So this idea of free market competition doesn't really exist when Congress, under the Exchange Act, said, if you're going to be a publicly traded company, you have to go through one of these SROs.
Peggy, what was your favorite part of the decision?
My favorite part of the decision was the rigorous statutory analysis. I think it just put to rest this whole business of it's just a disclosure rule, or this whole business of whole of government regulation. This decision has far-reaching effects that will put to rest a lot of this whole of government regulation across agencies, across initiatives, and across the various causes that this overreach is trying to do.
How about you, Sheng? What was your favorite part of the opinion? I liked how the majority really, called this rule out for what it was, rejecting SEC's claim that this was mere disclosure, and pointing out, hey, Nasdaq said these rules are meant for to attain what Nasdaq calls aspirational diversity objectives, and if they're not met, the majority made pretty clear, pierced the veil of pretext and said, if they're not met, then there's this public shaming penalty. These aren't just mere disclosure rules. This is a quota with a penalty. The penalty is not a fine, but it's having to basically raise your hand and say, put a dunce cap on your head.
And the very structure of the case, as we talked about earlier, in sealing the identities of the companies that were challenging this, proves that point.
Sheng, are there one or two takeaways that practitioners should really walk away from this decision with?
I think careful statutory analysis is key here. I think for decades, agencies, including SEC, has been able to run amok by claiming a lot of authority based on flimsy text. And courts haven't held them to account, but also at the same time, it's often because the folks on the companies on the other side of these cases don't make the arguments. But if you actually look at the text and interpret it carefully like this majority opinion did, you'll find that the SEC's claim of authority is often much smaller than what they've been doing in the past.
How about you, Peggy? Any takeaways for practitioners?
I think that major questions doctrine analysis is extremely useful and very well executed by the court. It not only went into the traditional elements about vast economic, political, and social significance, but it also talked about even the agency that is charged with regulating in this field, EEOC, doesn't have power to do this. And so these are all clues to practitioners that if you see somebody or an agency regulating totally outside of its spheres, a really good question to bring to mind is, okay, what about the agency that does have power? Is it doing this? And if so, why not? And I think that the major questions doctrine is very useful. It's very powerful, and it executed the court executed the analysis very skillfully.
Sheng, what would you say to people who just say, well, there goes the Fifth Circuit again, this sort of crazy right-wing circuit that is always trying to tamp down on regulatory power?
Well, I think you have to look at the NCLA victories in these en banc decisions. In Cochran, yeah, there were a bunch of circuits that went the other way, and the Fifth Circuit went our way. But then the Supreme Court, which ultimately makes these decisions, upheld the Cochran decision. Unanimously. Same in Cargill. It wasn't unanimous, but at the time we argued Cargill en banc, there were 3 other circuits that ruled against the position that we were making. The Supreme Court took Cargill up and affirmed NCLA's position.
Actually, and that was a 13-3 decision.
13-3, yeah.
Fifth Circuit en banc.
In fact, the Supreme Court actually went further than what the Fifth Circuit did, and said it wasn't just lenity, but it was just against the statute. And here, obviously, you can't really have a comparison between the Fifth and other circuits because the way
only
SEC,
one circuit's ever going to look at this.
Exactly. The way SEC regulations are challenged, it just goes to one, a randomly assigned circuit where someone sued.
Sheng, what happens next in the case now that the en banc Fifth Circuit has ruled? Will this case be going to the Supreme Court?
I doubt it. I've every confidence that NCLA would prevail if it went to the Supreme Court, but the respondent Nasdaq has already said that they accept the court's decision and don't intend to seek further review. SEC has said that it's considering its options, but given the upcoming change in leadership in SEC, I'm skeptical that they will seek further review.
Thank you for tuning in to NCLA's program about the recent decision in the AFBR v. SEC case striking down the board diversity rule. Please subscribe to our YouTube channel, X, and our newsletter, and you can find out more information about this case and other cases that NCLA is involved in, and you'll find the links to those things in the description for this video.